Waiting for the recording. Okay. Um, thank you. I'm preaching to the wrong people now, but I'm disappointed about the class attendance for this course. Same faces every time, and very, very few students that actually make the effort to join the classes. If students are not going to be attending class, I'm going to stop teaching, and then you can just do everything self-study or listen to the pre-recorded lectures that are available on email. There are PowerPoints with pre-recorded lectures available on the e-learning site. They date back to when everything was online during COVID. They are there. You can download them. They can listen. You can listen to them as additional study material. Then I've just looked at your course outline, and it seems I was confused when I prepared this course outline. According to the course outline, you're supposed to do quiz 1 this coming Friday already. But we only do Unit 8. The quiz covers Units 1 to 8, so everything about the law of contract. We only do Unit 8 next week, so obviously you can't do the quiz this Friday. It will be next Friday, the 27th of March. I will send out a formal notice, but just be aware of it in the meantime. Let me share my screen quickly. Thumbs up there if you could see the screen. Thank you, Mr. Links. Ms. Kantewa. Okay, so we're carrying on with the law, the general law of contract. Save a little bit of typing time. I actually did a copy and paste from the notes that I made while I was teaching the same work to my accounting students, the Introduction to Law for Accountants, because the first part of the two courses, even though it's different study directions, a contract is a contract, whether you're an accountant or a sports manager, basic laws of contract remain the same. So to save a bit of typing time while I'm teaching, I just did a copy and paste. So just remember now, let's get it onto a new page here. We are now dealing with a valid contract. We have learned what are the requirements for a contract to be valid. 5 requirements, and for a contract to be valid, all 5 these requirements, I'm just trying to find them here. There you are, 5 requirements for a valid contract. All 5 these requirements must be present for the contract to be valid. Now we are dealing with a contract that is valid. So it stays valid. It doesn't suddenly, randomly, abracadabra, become void. Once it is valid, it stays, it remains valid. Please remember that. That is important. You tend to get confused about that. But now in Unit 6, we're looking at breach of contract. What is breach of contract? Breach of contract is when something goes wrong. When a party does not perform in terms of the contract, whether if they perform late or they perform, so not they either don't perform at all, or they perform late, or they perform in the wrong manner. This is known as breach of contract. There's a whole list of different types of breach of contract. You need to know, you need to be able to recognize these various types of breach. Because this course is offered at level 6, which requires a bit more insight, a bit more application. Even though the concepts are the same, the assessment methodologies differ. I can also ask you to give me your own example of, for example, whatever type of breach I am referring to. A reminder there, we did this end of in last week. We looked briefly at the parties to a contract. We learned that the debtor is the person who has the duty to do something. The creditor has the right to receive performance. Need to know this because it will also help clarify the different types of breach. First type of breach we looked at is mora debitoris. Mora debitoris, that is when the debtor performs late. Easy to remember, or should be relatively easy to remember, this Latin word. I try to avoid Latin terminology. But if there's no English equivalent, I do have to give you the Latin. There's no English equivalent for this. Mora debitoris, but it's relatively easy to remember. Debitoris, you're talking about the debtor, the person who has the duty to fulfill the obligation, the duty to do. Mora, same Latin word, Latin root as the word tomorrow. So instead of today, he is performing only tomorrow. He is performing late. This is a type of breach of contract. But now, how do we know? How do we know when? When is the debtor late? That will depend on the precise contract. Obviously, if there is a fixed time, a date stipulated, if the date for performance is stipulated, contract says you have to perform on the 19th of March. By the 20th of March, your performance is late. Some instances, a date isn't stipulated, but it is obvious from the contract that immediate performance is required. If the geyser in your house breaks and you form the plumber, it is fairly obvious that they need to come as quickly as possible. If your geyser has been out of action for more than a week, then they are late. If no date is stipulated and immediate performance is not necessarily required, and the contract doesn't stipulate a precise time, so if no time is determined, then performance must take place within a reasonable time. When is a reasonable time? What is a reasonable time? Reasonable is one of those legal terms that we lawyers love using if we don't have a precise answer. Reasonable time will depend on the circumstances of the contract, depend on what exactly the performance is. But because there was no precise time uh, stipulated and different people's concept of reasonable might differ, it could be difficult to know when is the debtor then in breach of contract. Because one party might think a week is reasonable and the other party might think, oh no, I've got a whole month to perform. To avoid confusion in cases where no date was stipulated, the party expecting performance must give notice. They must put the debtor, the creditor must put the debtor on terms, give them notice. The law doesn't stipulate that it has to be a written notice, but in most instances it is and it should be. So you need to give them notice and give them then, as from the date of notice, a reasonable time to perform. So you can't give them notice and say perform now immediately. You need to give them notice and say perform in 2 days, perform in the week. Calculation of this reasonable time in the notice takes into consideration, however, um, how long you have already waited. So if you've already waited a month, you don't have to give them another month. But you do have to give them at least some time. So you specify then a date for performance. If they haven't performed by that date, then they will be in breach of contract. Next type of breach, mora creditoris. Now, if you compare the two names, mora debitoris, mora creditoris, mora debitoris, the debtor performs late, might leave you wondering now, what is this? Because the creditor doesn't have to do anything. So if you don't have to do anything, how can you be late in doing it? Mora creditoris in this instance doesn't refer to the creditor not having to do or doing something late or not doing it in time. It refers to instances where the creditor does not make performance possible. So those will be instances where Mr. Links, for example, has purchased something from Mr. Hayala, and the arrangement is that Mr. Hayala will deliver it on Friday. Mr. Hayala arrives, he tenders performance he wants to deliver, but Mr. Links is not at home. So it's a breach of contract by the creditor in the manner of not making performance possible. Please, people, have reference to Unit 6 of the notes. There are practical and easy to understand examples of each of these various types of um, breach of contract. And the examples, I believe, probably explain them a lot better than I do. So that is mora creditoris. Next one, defective performance. I don't need to elaborate on that. It is exactly what it says. If there is performance, but performance is not rendered in the manner as agreed. So there is performance, but it is defective. Creation. Repudiation, instances where the debtor has indicated by way of words or actions that they are repudiating the contract, that they are not going to perform in terms of the contract. In its most clearest, easiest manner is Mr. Links and Mr. Ayala have entered into a contract. Mr. Links has bought something from Mr. Ayala, and before delivery, Mr. Ayala says, well, I'm not going to deliver it. I've decided not to continue. Sometimes it's not expressly, it's done by way of action. If I remember, Mr. Sharuma is a rugby player. Am I correct in that? Do I remember correctly from last week that you used to play rugby? I think so.
Yes, yes, you are correct. Yes, you are.
Okay, so let's say Mr. Sharuma signs a contract with NUST to play rugby for the NUST Rugby Club. Don't know if we have a rugby club, but hypothetically, Mr. Sharuma signs a contract that he will play rugby for NUST. And then the first match of the season, he runs onto the field for UNAM without having informed NUST that he's not proceeding with a contract or anything. He just randomly, or maybe even in the middle of the season, he starts playing for NUST, and then next Saturday when there's a match, suddenly he runs onto the field for UNAM. Breach of contract by way of repudiation. His action by starting to play for a different club indicates that he has no intention of continuing with his original contract with NUST. Repudiation. Similar and sometimes factually confused with repudiation. It's sometimes difficult to distinguish between the two, is prevention of performance. Prevention of performance, a deliberate act that makes few permanent, makes performance impossible. The example that I have here in the study guide, I like to keep my examples, if I can, keep them sort of sports related. The example I have in the study guide is where a cricket player agrees to lend her teammate her bat for a particular match, and then just before the match, she deliberately breaks the bat. She smashes it. So she has prevented, so she can't lend it to her teammate. Breach of contract, a deliberate act preventing performance. Be careful here when we talk about prevention of performance. It is a deliberate act. At a later stage in the next unit, we get to, but what happens if the bat broke accidentally, if it was caused, if the performance cannot take place, but due to circumstances beyond the control of the parties. For breach of contract, we're talking about a deliberate act. Now, how does the law protect you? If there was breach of contract, that doesn't mean that now you have to suffer the loss. The law provides for certain contractual remedies. A remedy, like a cough remedy, a medicine, similar type of thing, a remedy, something to make up for the breach of contract. Now, there are a number of different contractual remedies that are available. But people, please remember, the contract remains valid. Very, very common mistake that students make, that they'll say, oh, there was breach of contract, now the contract is void. No, the contract isn't void. If a contract is void, there will be no remedies. A void contract is a nothing. There are no rights and duties in terms of a void contract. So if the contract were to suddenly go void, you would not be protected. Remember that. The contract remains valid. Now, our remedies, and I'll elaborate on them a bit more. You can claim, in the case of breach of contract, either specific performance or cancellation. Please note, it is specific performance or cancellation. It is the one or the other, never both. And in addition to either the one or the other, you can claim damages if you can prove that you have suffered damages. So it is specific performance or cancellation and damages. What is specific performance? Literally exactly what it says. A court order ordering the defaulting party to perform in terms of the contract. Now, in cases of breach of contract, this is the preferred remedy. As you learned when we were looking at the contract of restraint of trade, our courts are very much in favor of upholding contracts. That if the argument is, if parties entered into a contract to start off with, they wanted to achieve a specific result, and the court should assist them. So the courts don't actually like cancelling contracts. If it is at all possible, they will order specific contract, a specific performance. So it is the preferred remedy. It is not, however, available if the type of breach was prevention of performance. Obviously not, because then prevention of performance, you literally make performance impossible. So if performance is impossible, then obviously the court cannot direct you to perform because it's not physically possible. Courts are also unwilling to grant the remedy of specific performance if performance is of a personal nature, which is often the case with professional sporting contracts. So if Mr. Sharuma breaches his contract with NUST and suddenly starts playing for UNAM, it is very unlikely that a court would order him to go back and play for NUST. You can figure out the reasons behind that yourself. If you don't want to play for a club or want to play for a specific coach, a court forcing you to do so is definitely not going to lead to you performing at your best. And another reason why when specific performance will not be ordered is if specific performance will cause a disproportionate loss. So apart from those cases, specific performance is the preferred remedy. If the specific performance cannot be ordered, the alternative is cancellation. So cancellation is the opposite of specific performance. The court orders that the contract must be cancelled. There's a difference. Note. The contract is cancelled. The contract doesn't randomly, abracadabra, become void. It is cancelled. When can you claim cancellation? Obviously, if specific performance is not feasible. So those instances that we mentioned there, or if the contract has a cancellation clause. In Unit 8, we look at terms of a contract, then we'll see what a cancellation clause is. Cancellation clause, briefly, a clause in the contract, an agreement that if there is breach, it can be cancelled. So if you have agreed at the time of contracting that the contract can be cancelled, then obviously that is the case. Potential test question there. Remedies for breach of contract or a claim for damages, specific performance, and cancellation. Is that true or false? Do you think that statement is correct? Fabiola, do you think that statement is correct? Read it carefully. Students tend not to read properly. Specific performance and cancellation. Is that statement correct? Think about it. You can share your answers on the group. Okay, so that is damages and cancellation, specific performance on the one hand, or cancellation on the other hand. In addition, you will always have a claim for damages. What are damages? Damages, money, monetary compensation. Do not, however, think that this is a get-rich-quick scheme. You have to prove that you actually suffer damages and prove the amount lost. Only patrimonial damages, so that's actual monetary loss. Can be claimed. So the fact that your heart is sore or your ego is wounded and you're feeling sorry for yourself, you cannot claim money for that. You can actually only claim the amount of money that you would have gained, if I can use that word, if the contract had been properly performed. The purpose of damages is to put the creditor in the position he or she would have been if the debtor performed according to the contract. In other words, if there was no breach. So not extra money. You don't make money. It's just the purpose of damages is just so that you don't lose money, but you don't make money out of breach of contract. Only patrimonial losses, no damages for pain and suffering. What must you prove? Firstly, that there was breach of contract. You also need to prove the amount that you lost. You need to prove causation, that the breach actually caused the damages, so that there is a direct link, that the damage was reasonably foreseeable or agreed upon by the contractants. So when the debtor breached the contract, he should have or could have reasonably realized that the other party would suffer damage and how much damage. Innocent party cannot sit back and rub their hands together and think, oh, now I'm going to get a lot of money. They also have to take all reasonable steps to mitigate, to reduce the loss. If you can meet all those requirements, you can claim your damages. Any questions? No questions so far. Okay, we need to do Unit 7 as well. Unit 7, literally just terminology, words that new legal terms that you have to understand. Remember, once again, we're talking about a valid contract. It doesn't suddenly go void. A contract, once it is valid, doesn't become void. Remember that. Termination of contracts, potential question there, identify the manner in which the contract has terminated. Now, the most obvious manner in which contracts will be terminated is by performance. You enter into the contract with the aim of achieving something. Once that goal, that aim has been achieved, your contract terminates. Sometimes contracts are time related. So if our rugby playing friend has entered into a contract to play rugby for us for 1 year, then after that year, the contract will terminate. So effluxion of time, expiry of time. Study guide uses the word effluxion. I don't like the word effluxion. Expiry says the same, means the same thing. It's just a nicer word. Then contracts can also terminate by way of agreement. A contract is an agreement by its very nature. That's the first thing you learned this semester, is that a contract is an agreement. Now, if you can agree to enter into a contract, you can similarly agree to end your contract. There are different ways in which you can agree to enter into a contract, The first is release or waiver, where the one party agrees to release the other party, to tell them that they no longer have to perform. Be careful here, release is an agreement. You must be careful not to confuse release with breach of contract. If NUST has entered into an agreement with Miss Johannes that she will run for the NUST athletics, run a particular race, high profile race for the NUST athletics club, and they will pay her $5,000. And a week before the race, they tell her, Miss Johannes, you don't need to run for us anymore. They still have to pay her. If they say you don't have to run for us and we're not going to pay you, that would be breach of contract. Releasing her, they release her, free her from her duties, but that does not take away her rights. Be careful about that. And she doesn't have to agree, accept the release. She can say, no, I insist, I've got a contract, I will run. So don't confuse release or waiver with refusing, the one party refusing to continue with the contract. That would be repudiation or prevention of performance. Novation, that is where one novation, new contract, remember words sound similar. That is where one contract, an existing contract, is replaced with a different contract. NUST agreed to pay Mr. Chafuma $20,000 to play for the NUST Rugby Club. Then they speak to him again and say, well, instead of us paying you $20,000, you are allowed to study for free. We won't charge you study fees. And he agrees. His existing contract is replaced with a new contract. Novation. Compromise is similar to novation, except that compromise follows on a dispute. Mr. Chafuma believes the contract was for 20,000. NUST says, no, you misunderstood, it was for 10,000. They enter into a new agreement saying, okay, 15,000. Compromise, a new contract flowing after a dispute, meeting each other halfway. Contracts can then also terminate by way of operation of law, where something happens which has the result in law that a contract is cancelled, or is not cancelled, terminates, comes to an end. Just want to make this clearer to read. Oh, my typing isn't working here. I'm wasting your time. Let me not waste your time. Operation of law. Firstly, set off. Set off can only happen if the contract is about the payment of money between the same two parties, where two parties are reciprocally indebted to each other. Ms. Kanteva owes Mr. Links money, and Mr. Links owes Ms. Kanteva money due for a different reason. Ms. Kanteva owes Mr. Links $500. Mr. Links owes Ms. Kanteva $200. Set off happens. Ms. Kanteva only has to pay $300. You literally subtract the smaller amount from the bigger amount. Merger. Sometimes students find this one a little bit complicated. It doesn't have to be. Merger takes place where, due to circumstances, the same person becomes both debtor and creditor. So Mr. Ayala is renting a room from Mr. Links. Mr. Ayala subsequently buys the house. So now he is the owner of the house. The lease agreement will terminate as a result of due to merger, because you cannot be debtor and creditor simultaneously in the same contract. Extinctive prescription, something you might not know. We have a thing called the Prescription Act, which lays down different time periods. Debts don't last forever. We don't study the Prescription Act in detail, but contractual debts will prescribe, fall away after a period of 3 years. So if you've entered into a contract and the other party does not pay you or do what they're supposed to do, and you do not do anything, take any steps to claim performance, then after a period of 3 years, they no longer have to perform. Your debt will prescribe. And then the last one, supervening impossibility of performance. That is where performance becomes impossible after contracting due to reasons beyond the control of the parties. Be careful here, make a note of this. We looked at the requirements for a valid contract. We learned that if performance is not possible before or at the time of contracting, the contract is void. Objective impossibility of performance. We used the example last week of having to score, I think it was 200 goals within 200 tries within the space of a single rugby season. And we agreed that even if you are the best top rugby player in the world, you're not going to be scoring 200 tries within a season. Performance is objectively impossible. The contract is void. If you have a valid contract, I'm repeating myself again, once the contract is valid, it doesn't suddenly become void. If the contract is valid, something happens due to reasons beyond the control of the parties, so that performance is no longer possible. Supervening impossibility of performance, the contract will terminate. If performance is no longer possible due to the actions of the contracting party, this is prevention of performance, which will be regarded as breach of contract. Remember, I warned you there. Prevention of performance, a deliberate act. Distinguish that from something which is beyond the control of the parties. That will be supervening impossibility of performance. Contract terminates. Thank you. That's it for today. Do you have any questions?
Ma'am, just a question regarding assignments. Where do we submit them? Because on e-learning, there's no Turnitin or
I need
e-cert.
to, I need to, I need to, I need to, I need to. I will sort that out this afternoon. I will create the link for you to submit.
Okay, thank you.
Any further questions?
Amos, can you please add me to the e-learning platform?
Can you send me a WhatsApp, please?
All right.
Because I'm not going to remember. So just add me to, send me a WhatsApp, please. Then I will do it. Okay. More questions? If not, thank you once again for joining. I'm enjoying teaching you. But disappointed about your classmates that aren't making the effort to attend classes. Although the recordings are available, I do think you learn more if you're actually listening to me contemporaneously at the time. So thank you very much. Have a lovely weekend. Bye.